clip that in there.
Okay.
No, that's really interesting. So conversational AI is this new term where it basically replicates all of our conversations. So fantastic for sales, customer service, telemedicine. So Grace, for example, have replicated the conversation between a patient diagnosed with terminal cancer and a doctor, because when you get that news, you often go into shock and you're told once, here are the recommendations, don't eat, follow these routines, and people don't take on that information. So by training the AI, it enables people to go back and ask a chatbot, and they've got it to 100% accuracy, but they've been testing, doctors have been testing it. So obviously it's very different when we then pass that tool on to a patient that might start asking questions about life and death, and questions that haven't been predicted. So anyway, I'd love to welcome onto the stage James.
Hi everyone. I do have time as well.
Would you like to introduce yourself, and we
sure.
can get started?
Have we got Tom? Has
Yeah.
Tom arrived as well?
Oh no, he'll arrive in a little minute.
Okay. Hi everyone, my name is James Wong. I work as a lawyer at Clifford Chance, which is a global law firm. In my job, I advise mainly large global companies on strategic issues, from the emergence of new technologies. So AI is a very big discussion at the moment, as you'd imagine, as well as negotiating transactions and big deals. So large client base in private equity and other financial sponsors who are looking at issues like AI at, I suppose, more of a portfolio level. So in terms of the choices around portfolio investments that they're making, how do we start to put the puzzle pieces in place for the years to come? I previously worked in Australia and New Zealand, as you can probably tell from my accent. Yeah, that's quite a dynamic marketplace as well. I think because of its size, it's able to act as a bit of a test bed for new products, new ideas. And so there've been a few projects I've worked on in healthcare AI, in financial services, and in government, which has been interesting to witness. So that's kind of background on me.
Fantastic. Any initial questions? No. Okay, cool. Well, I'm going to kick off, and then of course Tom is going to be joining us as well on Zoom. He's in Bristol. So my first question is, what types of conversations are you currently having with clients regarding the EU AI Act, and how are companies preparing for it?
So EU AI Act, it's still quite early days, to be honest. So some of my clients are like quite large global corporations who you'd probably expect to be earlier on in the piece. But a lot of those discussions have been around horizon scanning. How's the landscape evolving? What can we expect in different jurisdictions around the world? And I think a lot of those efforts have been more around how do we make a meaningful contribution towards the development of these laws and regulations, rather than looking at the draft text and trying to come up with concrete proposals for how to move forward. So it is early days, and I think once we have a more concrete piece of draft legislation, we're still kind of looking at something that's now quite old, and the discussions have moved on, particularly the last couple of weeks. So it is early days. I think some of the conversations that we're having are a more strategic sort of conversations. So what are our current products that use AI in different ways? What does the roadmap of development look like over the next kind of 2, 3, 4, 5 years? And to be honest, a lot of the more kind of substantive discussions around concrete steps have been around getting kind of more basic things in place. A lot of organizations are still struggling with, I would argue, more fundamental things like what data do we hold, how is it governed, where is it, as particularly large organizations have quite an aggressive timeline for implementing new systems, reaching new customers, expanding into new markets, you very quickly end up with like a trail of systems, legacy systems, things that work in parallel. So even relatively like kind of core elements of the GDPR are still elements that organizations are trying to uplift to. So in terms of preparing for the AI Act, those discussions have been centered on, well, have we got the fundamental building blocks in place? Because once you start to comply with more and more regulations, the AI Act, but also different laws around the world which are emerging, it'll be so important to have those fundamental foundational building blocks in place. Otherwise, there'll be a lot of kind of remedial homework to do.
So can you describe, you mentioned healthcare and governments as some of your clients. Can you describe the types of AI systems that they're currently building and some of the opportunities, as well as, you know, there are plenty of risks, but what are the opportunities for these entities?
Yeah, so I'm very excited about AI, which is, I suppose, why I work in this space. I'm an optimist for the kinds of things that AI can do for society. And I think this question around some of the kinds of AI systems that I'm seeing, I think the threshold question is, what is an AI system? And the EU AI Act uses quite a broad definition of AI. Paraphrasing a bit, it's kind of any system that brings in some sort of input around a particular set of circumstances, analyzes that, and gives some sort of output. Now, it's a little bit more technical than that, but that actually encompasses a lot, or could encompass quite a lot. And so the kind of fundamental problem that I have is, okay, if we're going to try and name some use cases, some applications, some AI systems, does that include a lot of things that have already existed for 10, 20 years? So a lot of software systems could be caught under the definition of AI that we're looking at in the draft proposal. In terms of some of the things that I've been seeing with my clients, I think a lot of stuff which is AI is kind of relatively basic stuff that we've seen for a while. So ongoing conversations around recommender systems, around targeting products to particular segments of customers, targeting advertising. There's a lot of process automation. So how do we make existing processes that are done by humans a little bit more efficient? I'm seeing a lot of implementations of systems like ChatGPT. So one of the most powerful, I think, immediate use cases within most organizations is to speed up the process of brainstorming. So if you think about 20 years ago when you wanted to have a discussion around, okay, what kind of product do we want to design next, or which market do we enter next, and there'll be kind of a boardroom full of people who will spend a day kind of mapping out different ideas on a whiteboard. That process is now so much faster thanks to things like ChatGPT. So you might not kind of consider that the traditional process automation, but we are truncating the timeline for some of these kinds of conversations. In the financial services space, there's a lot happening in fraud prevention and detection. So a massive problem, particularly for a market like the UK, where finance is a really important pillar of the economy. A lot of money is spent detecting and preventing fraudulent transactions. And you're always up against people who engage in this sort of behavior, kind of catching up with the detection systems that we have. AI is going to further accelerate that, and so we're seeing associations of banks, of financial institutions, of insurers using AI increasingly to detect and prevent fraudulent transactions, fraudulent payments. And then in healthcare, I'm particularly excited about the role that AI can play in diagnosis of conditions, of diseases. Using large data sets, and we know, of course, the NHS has the largest healthcare system in the world, so a lot of healthcare data, a massive source of competitive advantage for the UK as compared to the global landscape. Using that data to have more consistent approaches to detecting at earlier stages diseases as they come up. And then I'm also excited about applications that I'm seeing in transportation and city planning. So we're seeing a lot of applications of how do we optimize problems like distribution of goods and providing packages to consumers faster and more efficiently, using less petrol in more environmentally friendly ways. And I think we've got Tom join us.
Welcome.
Hello, Tom.
Hi, Tom. Thanks for joining
Hi,
us.
Well, thank you so much for having me via Zoom.
Would you like to introduce yourself to our audience who are here today? I can just give you a little preview of our audience.
Brilliant. Hi, everybody. I'm Tom Whittaker, a senior associate independent UK law firm, Burges Salmon. I am a technology lawyer when I want to be an optimist, but in effect I'm a dispute resolution lawyer. So I'm often going to court or going through regulatory enforcement. So I think about things from a risk management perspective, but I've been advising on the EU AI Act and other AI regulation as well. It's great to be with you.
How's the sound? It's okay? Great.
A little bit louder.
Oh, a little bit louder.
It's just there's so much noise from the cafe, at least up here.
Okay. Let's see. So we're on question 2, and I'd love to pose that to you as well, which is, can you describe some of the types of AI systems that your clients are developing at the moment? So looking at more of the opportunities within the space.
Certainly. So one of our main clients who advises on the EU AI Act is one of the world's largest foundation model providers. And so from their perspective, they've got quite a range of downstream opportunities in terms of where their AI systems may be deployed, but also some of the third-party infrastructure that they can provide. So it's really, the opportunities are in some ways endless in the types of output that can be generated by generative AI, the ease with which it can be implemented within their clients' systems, third-party systems, with which people can use it as well. But I think very much with those opportunities come risks as well. So that whilst you see these applications in different sectors, you then see very sector-specific risks appearing. You have to integrate that with existing regulation for those areas, and also there is a risk that people approach the opportunities without proper analysis and understanding and management of the risks as well. But the big ones that I can see from our side are very much in the healthcare, financial services and public sectors.
Wonderful, thank you so much. Unfortunately, my audio is not the best, so you might have to just speak up a little bit. But can everyone more or less hear what's going on? Okay, good. So what steps should companies take to prepare for the EU AI Act, especially determining if they fall under the high risk category? Do you want to go ahead first?
Yeah.
Go ahead.
I can start. But so I think the first step is really to create some sort of inventory of all the AI systems that, or things that could be AI systems, depending on the interpretation of the Act when it comes out. That might seem like a fairly basic thing, just making a list. But particularly in a larger organisation, making a list can be a very challenging task to undertake, particularly where you have a fairly distributed organisational structure with lots of different things under lots of different people's control. And particularly in the cultures of some technology companies where employees are encouraged to experiment, to try things, there can very frequently be lots of different things happening in the organisation that the legal team, the compliance team, the kind of management teams don't know about. So that's kind of the main first step, and then it'll be a question of applying the definitions in the EU AI Act. against that inventory. That's kind of the kind of basic piece. Maybe I'll hand over to Tom so that we can kind of keep it moving.
Thank you very much. Yeah, I agree with all of that, and especially the difficulties of creating such a list. And where I'd take that to next is by identifying the stakeholders, both within your organisation and outside. The issue that I've heard from various is that it's quite hard to know where to place your risk management and your overview teams within the organisation. Is this led by the data protection privacy team? Is it led by the commercial, the product teams? Is it led by the legal and risk teams? And the fascinating thing I find about AI is it's very much cross-sector, it's very much cross-sector specialism, and so you need to get buy-in from all of them. Now, the risk is that too many cooks spoil the, whatever the phrase is, spoil the phrase. So you have too many people involved in effect, and you then don't have anyone who has clear ownership and accountability over the AI system. And the AI Act is clear to say that there needs to be a proper human oversight and accountability with AI systems.
So mapping those stakeholders, knowing who needs to be informed, who needs to make decisions, what they need to know and when is particularly important. Back to you, James.
And final thing that I would add is just around some of the rights that might emerge out of the AI Act. Over the last couple of weeks, we've seen discussions around potential rights that humans, that individuals that are impacted by AI systems might have. So they might have the ability to complain about an AI system. They're likely to have the ability to request an explanation, a description of how the AI system works. And just from I'd be interested to hear what you have to say on this, Tom, but advising organizations of all different sizes on GDPR compliance, that is an issue that isn't always easy to do. So responding to requests, responding to communications that you receive from different stakeholders can be quite a time-consuming and resource-intensive exercise. In terms of preparing for that, I think it's about having those basic pieces in place first. So having the documentation in place, knowing who's responsible for which components of a system, where they sit, how to contact them, what the escalation pathways are, so that when these requests come in, you can kind of not be waiting around for too long before you kind of get out of the starting blocks and respond.
I'd agree with all of that, and I'd broaden it out so it's not that. So it's GDPR requests are particularly important, but then also potential litigation, regulatory queries, questions, indeed in questions from investors and other stakeholders who need to understand the processes that you have, and you then need to map out whether there is a legal basis for that and whether you are required to respond, or whether you think it's also in your commercial interests to respond as well. And the risks that I've seen from some clients before is that without that mapped in advance, without taking a proactive approach, you become entirely reactive. So you may not have the right people, the right documents, the right processes in place. And then there is also a risk that things fall between the gaps. So if something gets escalated to one person in your organization, if they're on leave, if they don't pass it on an escalator, then the right people don't know about these things at the right time. So there's a lot of preparation that can be done with mapping these things out, but bearing in mind that even with the best laid plans, they still aren't always brilliant when it actually comes to it. So you need to have that flexibility as well. But there can be particular foundations you can get in place now.
Wonderful. And I agree that sorting out the data strategy before looking at AI strategy is fairly fundamental. I'm not sure if you've had any clients that start to use synthetic data instead of, the real company data.
I can, yes, but can't really say much due to the nature of it. But it's within in the public sector for certain criminal investigations and law enforcement, where they're trying to use synthetic data rather than actual data, which can be highly fraught with personal data, ethical issues about using data from victims of crime to be able to inform their models. And so instead want to use synthetic data to try and address some of those privacy issues, ethical issues, but still allow them to then meet those operational and legal obligations that they have to try and enforce the law. But yes, there's it's a I know the ICO as well has written about synthetic data too, so it's an active field. But James probably knows
We've
more.
got 2 questions from the audience.
I'll be allowed to ask questions
Yes,
during
please do.
Okay, great. Firstly, is it possible to give a quick response to how does GDPR and the new EU AI Act, how do they intermesh?
How does yes, exactly. How does the GDPR and the EU AI Act work together, or do they contradict one another?
Forgive me if I'm wrong, but I think James is probably better placed with GDPR, but happy to give it a shot.
So GDPR is primarily concerned with personal data. And that means that we're dealing with a subset of the data that's out there. It means that there are certain data sets that GDPR is not interested in. And it also means that you can take certain steps in respect of a data set so that you can avoid parts of the GDPR. One bit that doesn't necessarily fully belong in GDPR is Article 22, which relates to automated decision making. And that was placed in there because of a little bit of overlap with the kind of data protection, data privacy side of things. But the new EU AI Act kind of massively expands upon that idea of automated decision making. So in terms of the overlap, in many ways, both regimes will apply once the EU AI Act comes into force, where we're dealing with processing of personal data in the AI kind of life cycle is firstly sourcing the data that you train your model on. That is a form of processing personal data if there's personal data involved. Then in terms of testing, then in terms of day-to-day use, there are touch points that you'll need to analyze and understand against GDPR requirements. So that's the first piece. The second piece is around all the different aspects of automated decision making. So the current requirement is that you can individuals have a right not to have their personal data used for automated decision making that will have a legal or other significant impact on them. But the EU AI Act is going to kind of touch that space in a big way, and that's where I might hand over to Tom.
The AI Act has been drafted with the intention that it works alongside the GDPR and that it is intended not to be inconsistent with the GDPR. There are certainly provisions which say that for certain deployers of high-risk AI systems, where applicable, then certain data protection impact assessments need to be carried out. But it's drafted in a way which is supposed to be consistent with the GDPR. So you would still turn to the GDPR in that respect. There is, however, that risk that whilst they say that it's supposed to be consistent and that meeting GDPR obligations will then satisfy certain parts of the AI Act, that is not how it will work in practice. So I expect this is very much an area to watch over the next year or two, depending on implementation period times, to see what further guidance and technical standards come out, both from the EU and also from standard setting organisations.
Wonderful. I've got my next question, but if you can hold on to that question, I'll ask you next. So how does the certification process work for high-risk AI applications, and is self-certification sufficient?
Maybe I'll give the short answer in the room and then hand over to Tom. So the short answer is that for high-risk AI systems, you have all the requirements in the AI Act, and then there's the requirement to actually check that all these requirements are made. There are some instances where that can be done internal to the organization, but particularly where we're trying to encourage this culture of accountability, in many cases, I think there's going to be a whole industry emerge around AI assurance, and that will be part of that will be performing these conformity assessments, as they're called, in the draft legislation. Tom's actually quite a big expert on this. You've probably written about it more than most. But do you want to go into a bit more detail about how the certification process works?
Thank you. So there is the step where you have to well, depending on who you are, you'll have to consider whether a conformity assessment is needed and whether your AI system or systems may be considered high risk. And in the event that you do consider them to be high risk, then you would designate them as such, and that you go through the conformity assessment procedure. However, if you then decide that the system is not high risk, then you may have to make a notification to the applicable authority in order to confirm that's the position, and then you have to wait a number of months to see what the output of that is. So there is a risk that they will then come back and say, actually, it should be high risk, and you should have gone through a conformity assessment in any event. What I'd expect to see from many is that you have to do that initial analysis. What sort of legal entity are you? Are you a provider? Are you a deployer, etc.? Then working out what sort of AI system that you have so that you can start to map out what your potential obligations are. But in particular, to work out whether your AI system or systems is high risk. And then you will have that as a body of evidence to show your internal decision making, which will be relevant to many other aspects of what you do. And it will be from there that you'll then think, well, should you go through that notification process, and should you go through that conformity assessment process as well? And I'd expect that many will be taking a risk-based approach, risk-averse approach to going through those assessments and making notifications, because the alternative of saying that you're not high risk or not going through that process, only to find out that the authority then says you are high risk, and then you have to make substantial modifications. You may have to withdraw the system from the market. You may have fines. All of those potential consequences are so significant. Actually, it is more practical and commercially preferable to go through the notification process and conformity assessment process at the beginning. The reason why I chuckled towards the beginning about whether it was an effective process is that there's certainly been heavy criticism from certain fundamental rights groups about this self-notification procedure, and concern that those authorities may not have the right expertise or resources to be able to properly monitor and consider all of those notifications, and that these fundamental rights groups are very concerned that this is about self-regulation, and that there is a history whereby the technology industry, or at least certain within the industry, may have their own interests to play out, and they may not be aligned with broader societal fundamental issues as well. Obviously, many sides to that story, but there are certainly some people who are highly critical of this process.
Wonderful. So we were talking earlier about the recent partnership that's developed with OpenAI and Dropbox. So what is the responsibility of companies ensuring that their third-party suppliers comply with the EU AI Act?
So yeah, this is huge. The third-party piece is, I think, where a lot of organizations are going to have the kind of highest involvement with the EU AI Act. So you might not necessarily be building things yourself, but you'll be interacting with a whole network of different third parties who will play different roles. There will continue to be there will continue to be a role for supplier due diligence, and that role will expand. So this kind of process of assessing a vendor before taking them on is going to become even more critical. There will be all sorts of contractual norms that emerge around undertaking ongoing audits and assessments because of these requirements. Risk management on an ongoing basis is going to become very important. Because a lot of the obligations in the AI Act are around documentation, record keeping, logging, we should expect to see specific obligations around these in a lot of contracts with third parties. And then more broadly, you've got the normal things that you'd expect to see in a contract, but they'll become pivotal to the kind of AI environment, things like allocation of liability, indemnities, warranties, compliance with laws, who's responsible for kind of different aspects through the supply chain. These will become very important. And I think the practical challenge with a lot of this is that it is still quite early stages for some of the newer technologies. And so what is market practice, what is normal, hasn't really fully kind of matured yet. So I think there will be this process of the next few years of setting those norms. And I think that will be very interesting.
And I completely agree on that point about what is best practice or reasonable practice, especially in an area of a fast-moving, emerging technology where people are still coming to grips with it. That is particularly important from a legal perspective because you'd expect that contractual clauses will refer out to best practice or reasonable practice or what the market practice is. In particular, there's draft contractual clauses for the EU AI Act around high-risk AI systems, although very much in draft for discussion, and that then refers out to market practice. Similarly, in the UK, there's the Society for Computers and Law AI group, which has produced model contractual clauses. And again, that very much refers out to a series of schedules to be agreed between the parties, which then sets out what their agreed requirements are and what reasonable practice would be. So it will be very difficult to know for certainty in the future exactly what that will look like. You can probably take some assurance based off of, in the UK, the common law, in the EU, depending on the jurisdiction, whichever law will apply there, about how contracts will be interpreted or what the obligations are upon parties. But it will still be an area of legal and commercial risk to navigate.
Wonderful. I'm going to skip to the next question, which is, are there any provisions in the EU AI Act for law enforcement agencies to use software otherwise banned, like facial recognition? And can AI results be used as evidence in a trial?
I'm happy to go. So haven't seen the final text of the Act after the political agreement, and it's very likely that there will be further negotiations over the coming weeks and couple of months as well. So this is one of the highly political issues that there is, that goes to the heart of some of the exceptions within the Act. Certainly from what's been publicised and from the previous version, that there are exemptions for law enforcement for certain types of AI systems, such as facial recognition, subject to getting a judge's order in advance to say that they can be used. And you can certainly see that in practice at the moment with the World Cup in France next year, I think Atos is using facial recognition to assist French law enforcement authorities, live facial recognition. So there's obviously a view that many of these things can be used in some way, but you do have to carefully navigate the exceptions and the requirements of the AI Act. In terms of whether the outputs could be used within trials, not a criminal lawyer, so I suppose it will very much depend on how the police can then use it as evidence. And I can only think of it from the UK perspective of Police and Criminal Evidence Act, of whether it would meet those requirements. I think there is a wider point to be made, which is that any output of an AI system does risk being used within court cases or used in other ways as well. Even if you think you are managing it securely, you should be aware that there is always a risk of cyber attacks, of internal theft, and that output could be used in different ways. And so even if it's intended to be used as part of law enforcement, it could be used in other ways as well. And those risks need to be mitigated.
Not much to add on that. I think it's hard to comment too much until we do see the final text that's come out of the last couple of weeks of negotiations. It is hotly contested. I think it goes back to the forever debate around security versus privacy. So it'll be interesting to see the outcome. A lot of the participants in the trilogue debates have been quite heated in their contributions to that discussion. So I suppose we'll wait and see.
And it'll be very different in China, for example, how they start that use facial recognition to the EU. So I'll bundle my last question together and then take some questions from the audience. So how can the EU AI Act remain relevant amongst the ever-evolving AI technologies? And do we have enough experts to deal with the proliferation of AI?
How does it remain relevant? So this is actually quite a fundamental problem in making laws, and it's particularly pronounced in technology, and in recent years when technology has been moving at a very fast pace. The kind of simple solution is to keep things at a high level, keep them principles based or even values based. The difficulty there is that the actual precise application of those principles becomes a matter for interpretation. And do you leave that interpretation to the participants themselves, so tech companies who have the resources to employ lawyers to come to views on various principles? Or do you set kind of prescriptive rules? Compared to other regimes, the EU takes a comparatively prescriptive approach. So particularly for high risk systems, it's kind of maybe we should have kind of explained, given a summary of the regime, but you've got high risk systems. Sorry, I should start from the start. You've got prohibited systems that ban practices that are completely not okay. You've got high risk AI systems for which there are very prescriptive requirements, and then you have the kind of the lower limited risk systems where there are just kind of general principles. So not prescriptive requirements. You can still follow those same prescriptive requirements, but the requirement is more of a general one. And I'd add to that over the last couple of weeks, we've seen the insertion of a new category, which is around general purpose AI, including foundational models. And that kind of departs a little bit from the existing kind of approach that was taken to drafting. The criticism that some have leveled against the EU proposal is that as things develop, as technology changes, some aspects could become outdated and just be compliance for the sake of compliance. Different approaches have been adopted in different parts of the world. The US, as you might imagine, has taken a little bit more of a industry self-regulation approach, but they've identified specific areas where they want to regulate. And I'd say, as a broad brush statement, a lot of those are around consumer protection. China has taken they've moved quickly, but they've taken what I would describe as maybe a slightly vaguer approach, which allows more flexibility and enforcement, but you lose a lot of the kind of clarity and certainty. And I personally quite like the approach that the UK is taking so far, although I'd prefer emphasis on different things. But the UK has taken a little bit more of a let's kind of see how things develop. And the reason that the UK can confidently do that is because for many of the higher risk applications of AI, there is already context-specific regulation in place. So when we look at something like financial services, where there are lots of risks, and it touches many aspects of society, we have in place financial regulation. When you look at medical and healthcare applications of AI, there is product liability requirements around medical devices, etc. And so that kind of context-specific approach allows for flexibility for kind of AI innovation in general, but it also provides specific protections to areas where we particularly care about. So how do things kind of stay flexible for the future? I think keeping things high level. I think the way that will play out with the EU is that they'll have to make incremental changes and edit things through guidance in the years to come.
Just on the point about whether there are enough experts, that is a real concern at government level about whether there are enough experts, either within the public sector in order to effectively procure AI systems, but also within what's called the wider AI assurance ecosystem in the UK. And I expect that that will be an issue across the EU as well, about having the right people in the right places, especially whether they are part of the technology industry already, or whether they're part of regulators or part of governments to be able to push these things forward. But certainly in the UK, there is a very big push to improving the AI assurance ecosystem. The usual suspects, as you would expect, such as the lawyers, the accountants, the auditors, but then also there is a growing list, albeit still relatively small, of AI auditors and AI assurance experts who can then go in and red team your operations or red team a third party's operations, subject to whether they're allowed to, and who often find a way that they can then automate some of these processes as well. So going back to James's very original point about mapping out all of your AI systems, there are some providers who say that they can help you map those things out and then have an ongoing life cycle of monitoring and assurance over those systems too.
Wonderful. Hopefully using the Grace platform, which I advise you all to take a look at. So the question is, for global company that has offices in the US, maybe that's where they've developed, like OpenAI, for example, that has global reach, how will they deal with the two different systems in the US and the EU? Will they have two completely different products that get released? Or will they try and harmonize this, and will the EU take sort of the precedent or the
So there is a risk of a international regulatory patchwork, and there is political movements to try and bring greater international regulatory interoperability, as they call it, so to reduce the risk of that patchwork. However, I think it's inevitable that different jurisdictions will take different approaches, and in any event, different sectors will take different approaches, because the EU, the UK, and others have all said that risk is sector specific, and that there will need to be specific guidelines and regulations around those sectors. What you saw from OpenAI in the early summer, I think, was Sam Altman saying that they would just withdraw from Europe. Although he quickly then backtracked on that. And the way that the EU AI Act is drafted is that if you're unable to meet it, then there is the risk of those systems being removed from the market as well. So what I would expect for global companies to be doing is that, well, possibly one of two things. One is choosing which markets they operate in and potentially removing themselves from some markets because of the regulatory burden. Or alternatively, if it's possible to make it work legally, is a flight, I've forgotten the exact phrase, but a flight to the highest standard. So if the EU is seen as having a higher standard than the US, but that if you meet the EU, you also meet the US, thereby the company is likely to then be trying to meet both of them simultaneously. But it is a tricky one to do, especially when those regulations, as James has been talking about, will be adapting and evolving over time.
Yeah, I mean that's the approach we've seen to other pieces of legislation over time. So you either have this kind of high watermark approach where there isn't as much resource, so you just pick the one that looks like it's got the strictest requirements, which is often going to be the EU, and then everything complies with that standard. Now, I have problems with the approach because you end up with non-compliance in other areas. You miss things, and so the more expensive but more globally kind of compliant approach that global organizations take would be each time they're getting advice on how the product needs to be designed, they will get input from experts in each jurisdiction, a global review against local requirements, and that can be very expensive.